In this world, people meet, they fall in love, and promise to stay forever. But forever sometimes ends sooner than we think. And one day, two people who once couldn't imagine life apart find peace in separation. This is not just a story of love, it's a story of law, emotion, and a curse that echoes through generations. Divorce in India is not just emotional, it's a legal and financial struggle. When marriages collapse, questions of alimony and maintenance follow. There's no uniform rule. Every court decides differently based on income, lifestyle, and dependence. That's why one person may get 5,000 a month while another gets 50,000 in similar cases. Cases drag on for years, men call it bias, women call it a delay, and children live with the impact for life. This documentary uncovers these issues: the lack of uniform criteria for alimony, the slow pace of justice, and the imbalance that turns a personal breakup into a prolonged legal battle.
Under Section 125 of CRPC, anyone who has sufficient means but neglects or refuses to maintain his wife, children, and parents can be ordered by the court to pay monthly maintenance for them. This was created to prevent destitution and ensure basic survival. But in reality, this protection often comes too late. In case of Rajneesh vs. Neha 2021, Supreme Court noted interim maintenance, which was actually meant to give immediate financial support to the people, have been delayed by the courts. The court directed that all the cases should be directed in the span of 4 to 6 months. Yet across India, these cases are being delayed. A study shows that only 36% of cases are resolved in the span of 1 year in Indian courts. This delay defeats the very own purpose of Section 125. This delay hurts the people for whom the Section 125 has been made to protect them. According to the National Judicial Data Grid, 39% of cases are 1 year old in Indian courts. 27% of cases are pending from 1 to 3 years, and 17% of cases are dragging from 5 to 10 years.
In India, maintenance and alimony are governed by multiple overlapping laws, not one unified system. A single dispute can fall under Section 125 of Code of Criminal Procedure (CRPC), Section 24 or 25 of the Hindu Marriage Act, Section 20 of the Domestic Violence Act, or personal laws such as Muslim Women Protection of Rights on Divorce Act. Each of these laws provides separate remedies, procedures, and criteria, but none operates in coordination. Because of this, the same parties often approach different courts for similar reliefs. For instance, a wife may claim interim maintenance under the Hindu Marriage Act and also file a separate case under the Domestic Violence Act. This leads to multiple orders, conflicting amounts, and delayed enforcement. The Supreme Court in Rajans vs. Neha 2021 observed that such multiplicity creates confusion, waste of judicial time, and a risk of double maintenance. It directed that whenever multiple proceedings exist, courts must seek information on existing orders and adjust or set off amounts already awarded to ensure fairness. However, there is still no uniform formula to calculate maintenance across these statutes. Some courts consider only the husband's income, others include lifestyle, assets, or dependents. Even the starting date of maintenance differs. Under the Section 125 CRPC, it may begin from the date of application, while under the civil law, it often starts from the date of order. This inconsistency results in unequal outcomes for similar cases nationwide. The Supreme Court has urged the creation of a uniform maintenance framework, one that standardizes criteria, timeline, and procedures across all laws.
In divorce and maintenance litigation, courts repeatedly face the same problem. Parties rarely disclose their financial reality honestly. Across judgments, including those of Supreme Court and several high courts, it is evident that income is often understated, assets are hidden, and affidavits are incomplete. Courts have dealt with husbands who show minimal taxable income while controlling substantial businesses, and wives who suppress their own income or past financial settlements. These patterns directly influence the assessment of maintenance. Another issue is the suppression of marital facts. Some cases involve parties denying previous marriages, withholding details of past settlements, or challenging the validity of their own marriage to avoid legal responsibility. Courts have also encountered missing or damaged marriage documents and have clarified that even if primary evidence is unavailable, marital relationship can still be established through official records, cohabitation, and surrounding circumstances.
The first question is why do maintenance cases take so long and why people will not get justice even after so long time? The reason for it is the other party. Suppose if wife files maintenance case against the husband does not want to give the maintenance, he wants to harass the wife. He will drag on the proceedings even though there is a specific provision that maintenance cases have to be disposed within a time limit. Even for interim maintenance, it should be 60 days. But generally, they will drag on the proceedings. And moreover, there are a number of cases pending in the family court now due to many diverse cases, and as such, it takes time. Even though there is a time limit under law to dispose of the cases.
The main cause for this is the lacuna in lower level judiciary system and infrastructure. In our country, due to the illiteracy and poverty, the justice is getting delayed. The people in approaching the courts, proper lawyer, expenses and etc. All these factors play a key role in causing delay. Yes, it is true. Some of the parties are very intelligent and they try to mislead the courts and lawyers also. And they often succeed also. They hide their details such as working details, designation, income and etc. with a view to escape from their liability.
Then the Supreme Court, in the judgment, the reasonable judgment consisting of 3 judges, 2021, 1 ALD 216 Supreme Court, that is Hindu Malhotra judgment, is a famous judgment, wherein the court directed that the parties who filed maintenance, both the parties, should file an affidavit, assets and liabilities showing how much income they got, last 3 years bank statements, last 3 years income tax assessee if they are assessees, and they should disclose all the details of immovable properties, what is the expenditure they are incurring monthly. So there is no escape for it to many diverse cases, and as such it takes time, even though there is a time limit under law to dispose of the cases. Because the problem is, suppose if they are Muslims, they'll file the maintenance cases under 125 CRPC. Suppose if they are Hindus, they'll file it under section 18 and 20 of Hindu Adoption and Maintenance Act for maintenance of the cases. Suppose if they want divorce, they'll file a divorce case. In that they'll have option of having permanent alimony, they can claim permanent alimony, or as well as the interim maintenance under section 24. Likewise, Special Marriage Act got the provision, the Indian Divorce Act has got the provision. All the laws are, because they belong to which faith they belong and how the marriage is performed is the main thing that the court will consider. And as stated, the recent judgment helps the courts also. The parties, even though they file number of cases, but only maintenance as far as quantum amount will be granted. And suppose if any previous amount maintenance is granted by the court, it will be considered also by the court, and only one amount will be granted, consolidated amount, not the different maintenances which previously used to grant by different courts. And the husband used to suffer, but now it is not possible.
But the object behind all laws is one and same aim of justice. The governments After approaching the Law Commission only, they will enact the laws. Basing on the burning issues on various subjects only, the Law Commission will suggest for proper laws. The maintenance under Criminal Procedure Code and maintenance under Adoptions and Maintenance Act are one and same. It provides relief to the wives.
And the courts will see under which law it has filed it. There, because according to their faith, they will file it under different laws. So, basing upon that, the question before the court is not the faith and all that, but what is the income of the husband, and the wife has to live as per the standards of the husband. Suppose the children are there, and how much monthly amounts, payment of fees, school fees, medical expenditure, rental amount. So it depends upon each particular case. What is the income? Suppose if a husband is not earning more amount and his wife is a qualified, and some courts have come to the conclusion that husband is not bound to maintain the well qualified housewife. And she is not intentionally not doing anything to harass the husband, then court will also consider that. Some recent cases where postgraduates, highly qualified wife filing cases, court refused to entertain, stating that you are not supposed to sit idle. And suppose if maintenance has to be granted, then again it will take the assets and liabilities and of both the parties. It will grant only the quantum which the husband can pay it, because if he is not able to pay it, then there is again burden on him. So after considering all the aspects only, court will grant the maintenance.
Rajneesh and Neha were married in 2007 in Nagpur under Hindu rites and customs. They lived together for several years and had one son.
Over time, differences developed between them. Frequent arguments and misunderstandings strained their relationship. In 2013, Neha left the matrimonial home with their child and resided with her parents.
Neha filed a case in the family court at Nagpur asking for monthly maintenance under section 125 of CRPC. In 2015, the court ordered Rajneesh to pay 15,000 per month to Neha and their child. Rajneesh appealed against this order. The High Court dismissed his appeal and confirmed 15,000 monthly maintenance. Rajneesh then went to the Supreme Court of India.
Said he had no income and therefore couldn't pay maintenance to the wife. Denied ability to pay further maintenance. Stated openly before the court that he couldn't pay any more to the wife. Claimed financial struggle. Said he had to borrow loans from his father to pay earlier amounts. Promised to pay only for the child. He accepted paying maintenance for the minor son and said he would continue that.
She argued that child's existing maintenance was too low. 10,000 was fixed when the child was 2.5 years old in 2015. But now the child is 7.5 years old and school going. Accused the husband of hiding income. Claimed he had invested in real estate and other businesses, but was diverting income to the parents to avoid paying maintenance. Said he ignored court orders deliberately, despite Supreme Court and DV Act orders. He repeatedly did not comply.
In Rajneesh versus Neha, 5 major issues came before the Supreme Court. First, the husband argued that he was unemployed and couldn't pay maintenance. The court rejected this, saying an able-bodied man cannot escape his legal duty. Second, the case exposed how husbands and wives routinely hide their real income. To fix this, the court created a mandatory nationwide rule. Every party must file a detailed asset and income disclosure affidavit. Third, the court found that people file maintenance cases under multiple laws. The Supreme Court settled it. All maintenance order must be adjusted and set off across cases to avoid double payment. In the end, divorce isn't about right or wrong. It's about two people who couldn't stay the same. Love fades, word turn into silence, and what was once life together becomes pages in a file. What's left behind are memories, lessons, and a few broken promises.